From page 159, the top of 160. Validly prohibit a president's corrupt efforts to use his official powers to curtail, end, or interfere with an investigation. A. Statutory defenses to the application of obstruction of justice provisions to the conduct under investigation. The obstruction of justice statute most readily applicable to our investigations is 18 U.S.C. Section 1512 C2. Section 1512 C provides, C. Whoever corruptly, 1. alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or 2. otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fired under this title or imprisoned not more than 20 years, or both. The Department of Justice has taken the position that Section 1512 C2 states a broad, independent, and unqualified prohibition on obstruction of justice. Footnote 1077. See U.S. B.R. United States versus Kumar, numbers 65482 CRL 06-5654 CR-CON, Second Circuit, filed October 26, 2007, at pages 15 through 28. United States versus Singleton, numbers H04 CR 514SS H06 CR 80, SD, Texas, filed June 5, 2006. While defendants have argued that subsection C2 should be read to cover only acts that would impair the availability or integrity of evidence, because that is subsection C1's focus, strong arguments weigh against that proposed limitation. The text of section 1512 C2 confirms that its sweep is not tethered to section 1512 C1. Courts have so interpreted it. Its history does not counsel otherwise, and no principle of statutory construction dictates a contrary view. On its face, therefore, section 1512 C2 applies to all corrupt means of obstructing a proceeding pending or contemplated, including by improper exercises of official power. In addition, other statutory provisions that are potentially applicable to certain conduct we investigated broadly prohibit obstruction of proceedings that are pending before courts, grand juries, and Congress. C-18 U.S.C. Sections 1503, 1505. Congress has also specifically prohibited witness tampering. C-18 U.S.C. Section 1512b. 1. The text of Section 1512C2 prohibits a broad range of obstructive acts. Several textual features of Section 1512C2 support the conclusion that the provision broadly prohibits corrupt means of obstructing justice and is not limited by the more specific prohibitions in Section C1, which focus on evidence impairment. First, the text of Section 1512C2 is unqualified. It reaches acts that, quote, obstruct, influence, or impede any official proceeding, end quote, when committed, quote, corruptly, end quote. Nothing in Section 1512C2's text limits the provision to acts that would impair the integrity or availability of evidence for use in an official proceeding. In contrast, Section 1512C1 explicitly includes the requirement that the defendant act, quote, with the intent to impair the object's integrity or availability for use in an official proceeding, end quote. A requirement that Congress also included in two other sections of Section 1512. C-18 U.S.C. Sections 1512A2B2. use of physical force with intent to cause a person to destroy an object, quote, with intent to impair the integrity or availability of the object for use in an official proceeding, end quote. 1512b, 2b, use of intimidation, threats, corrupt persuasion, or misleading contact with intent to cause a person to destroy an object, quote, with intent to impair the integrity or availability of the object for use in an official proceeding, end quote. But no comparable intent or conduct element focused on evidence impairment appears in section 1512c2. The intent element in section 1512c2 comes from the word corruptly. See, for example, United States versus McKibbins, 656 F3D, 707, 711, 7th Circuit, 2011. Quote, the intent element is important because the word corruptly is what serves to separate criminal and innocent acts of obstruction, end quote. Internal quotation marks omitted. And the conduct element in section 1512c2 is, quote, obstructing, influencing, or impeding, end quote, a proceeding. Congress is presumed to have acted intentionally in the disparate inclusion and exclusion of evidence impairment language. See Loughran versus United States, 573 U.S. 351, 358, 2014, quote, when Congress includes particular language in one section of a statute but omits it in another, let alone in the very provision, this court presumes that Congress intended a difference in meaning, end quote. Quoting Rossello versus United States, 464 U.S. 16, 23, 1983, Accord Digital Realty Trust, Inc. versus Summers, 138 S. Court, 767, 777, 2018. Second, the structure of Section 1512 supports the conclusion that Section 1512c2 defines an independent offense. Section 1512c2 delineates a complete crime with different elements from Section 1512c1, and each subsection of Section 1512c contains its own attempt prohibition, underscoring that they are independent prohibitions. The two subsections of Section 1512 are connected by the conjunction or, indicating that each provides an almost always disjunctive, that is, the words it connects are to be given separate meanings. Oops, I read the next line. Indicating that each provides an alternative basis for criminal liability. See Loughran 573 U.S. at 357. Quote, ordinary use of or is almost always disjunctive. That is, the words it connects are to be given separate meanings, end quote. Internal quotation marks omitted. In Loughran, for example, the Supreme Court relied on the use of the word or to hold that adjacent and overlapping subsections of the bank fraud statute, 18 U.S.C. Section 1344, state distinct offenses, and that subsection 1344-2, therefore, should not be interpreted to contain an additional element specified only in subsection 1341. ID, see also Shaw versus United States, 137 Southern Court, 462, 469 through 465 through 469, 2016, recognizing that the subsections of the bank fraud statute, quote, overlap substantially, end quote, but identifying distinct circumstances covered by each. Footnote 1078. The Office of Legal Counsel recently relied on several of the same interpretive principles in concluding that language that appeared in the first clause of the Wire Act, 18 U.S.C. Section 1084, restricting its prohibition against certain betting or wagering activities to, quote, any sporting event or contest, end quote, did not apply to the second clause of the same statute, which reaches other betting or wagering activities. See reconsidering whether the Wire Act applies to non-sports gambling, November 2nd, 2018. Slip Op 7, relying on plain language, ID at 11, finding it not, quote, tenable to read into the second clause the qualifier on any sporting event or contest that appears in the first clause, end quote. ID at 12, relying on digital realty. And here, as in law friends, section 1512C's, quote, two clauses have separate numbers, line breaks before, between, and after them, and equivalent indentation, thus placing the clauses visually on an equal footing and indicating that they have separate meanings, end quote. 573 U.S. at 359. Third, the introductory word otherwise in section 1512C2 signals that the provision covers obstructive acts that are different from those listed in section 1512C1. See Black's Law Dictionary 1101, 6th edition, 1990. Otherwise means, quote, in a different manner, in another way, or in other ways, end quote. See also, for example, American Heritage College Dictionary online, quote, 1, in another way, differently, 2, under other circumstances, end quote. See also Gooch versus United States, 297 U.S. 124-128, 1936, characterizing otherwise as a broad term and holding that a statutory prohibition on kidnapping, quote, for ransom or reward or otherwise, end quote, is not limited by the words ransom and reward to kidnappings for pecuniary benefit. Colossus versus United States, 368 F3D, 190 200, 2D Circuit, 2004, construing otherwise in 28 U.S.C. section 2466, 1C to reach beyond the, quote, specific examples, end quote, listed in prior subsections, thereby covering the myriad means that human ingenuity might devise to permit a person to avoid the jurisdiction of a court, end quote. CF Begay versus United States, 553 U.S. 137, 144, 2006, recognizing that otherwise is defined to mean, quote, in a different way or manner, end quote, and holding that the word otherwise, introducing the residual clause in the Armed Career Criminal Act, 18 U.S.C. section 924E 2B2, can but need not necessarily, quote, refer to a crime that is similar to the listed examples in some respects but different in others. Footnote 1079. In Sykes versus United States, 564 U.S. 115, 2011, the Supreme Court substantially abandoned Begay's reading of the residual clause, and in Johnson versus United States, 135 SCT 2551, 2015, the court invalidated the residual clause as constitutionally vague. Begay's analysis of the word otherwise is thus of limited value. The purpose of the word otherwise in section 1512C2 is therefore to clarify that the provision covers obstructive acts other than the destruction of physical evidence with the intent to impair its integrity or availability, which is the conduct addressed in section 1512C1. The word otherwise does not signal that section 1512C2 has less breadth in covering obstructive conduct than the language of the provision implies. 2. Judicial decisions support a broad reading of Section 1512C2. Courts have not limited Section 1512C2 to conduct that impairs evidence, but instead have read it to cover obstructive acts in any form. As one court explained, quote, this expansive subsection operates as a catch-all to cover otherwise obstructive behavior that might not constitute a more specific offense like document destruction, which is listed in C1, end quote. United States versus Volpendesto, 746, F3D 273, 286, 7th Circuit, 2014, some quotation marks omitted. For example, in United States versus Ring 628, F supplemental 2nd, 195, DDC 2009, the court rejected the argument that, quote, Section 1512C2's reference to conduct that otherwise obstructs, influences, or impedes any official proceeding is limited to conduct that is similar to the type of conduct prescribed by subsection C1, namely conduct that impairs the integrity or availability of records, documents, or other objects for use in an official proceeding, end quote, ID at 224. The court explained that, quote, the meaning of Section 1512C2 is plain on its face, end quote, ID alternations in original. And courts have upheld convictions under Section 1512C2 that did not involve evidence impairment, but instead resulted from conduct that more broadly thwarted arrests or investigations. See, for example, United States versus Martinez, 862, F3D, 223, 238, 2nd Circuit, 2017. Police officer tipped off suspects about issuances of arrest warrants before, quote, outstanding warrants could be executed, thereby potentially interfering with an ongoing grand jury proceeding, end quote. United States versus Arensfield, 698, F3D, 1310, 1324 through 1326, 10th Circuit, 2012. Officer disclosed evidence of an undercover investigation to its target. United States versus Phillips, 583, F3D, 1261, 1265, 10th Circuit, 2009. Defendant disclosed identity of an undercover officer, thus preventing him from making controlled purchases from methamphetamine dealers. Those cases illustrate that Section 1512C2 applies to corrupt acts, including by police officers, that frustrate the to be continued.